Thank you, all of you who are here in person. I think as the summer goes on, people head out to various other things that they do, and I'm grateful to those of you that are here and many of you on the phone. A little bit of background. I'm going to be following the one-page outline that's posted on the website, and it's also available on the table just outside the seminar room. About midway through the outline, I'm going to pause so we can take questions partway through, and then at the end we'll have time for more questions. And for those of you on the phone, please do email your questions and they'll be presented to me at the appropriate time. So please write down those questions as we go. I want to say a little bit about my own background. I'm an environmental lawyer by training and practice. Been doing environmental law for 35 years at this point. First job out of law schools at the Interior Department and in the solicitor's office, which is a great place to learn in environmental law, and was involved at that time with setting up and helping to set up the Surface Mining Control and Reclamation Act program, one of those federal environmental programs that actually does affect land use pretty directly. After that, I was with a private firm here in D.C. for 6 years, and I joined the ELI staff in the mid to late 1980s. So my experience is largely environmental law, but over time it became important to look at land use law because much of what affects the environment is what we do with the built environment, where we put our houses and our factories, how we deal with transportation and the like. And so got quite involved with local environmental law or land use law probably over the course of the last 15 to 20 years. And there's been a developing trend, I think, for people to see land use law is connected with environment in a way that was not true when I got into this profession 35 years ago. So those of you that are looking professionally for places to work, among the things that you might consider in addition to the federal agencies and the state agencies are the many state and local governments that have a very direct effect on what our environment looks like and what happens to our waters and land and biodiversity. In the last few years, ELI has put out a number of reports, some of the ones I've worked on that are directly connecting land use law and environmental law are, for example, our Planner's Guide to Wetland Buffers for Local Governments. There's a Federal Clean Water Act provision that protects wetlands directly, but protecting the areas surrounding wetlands, that's largely an area that's up to land use law to address. And thousands of local governments around the country have taken different means of doing that. Another emerging area, where do we site wind farms, wind power facilities? For the most part, there's not a federal law that says where you site these. Some of the states have laws like that. A lot of it's left to local governments, where the zoning ordinances allow or prohibit or limit wind farms. And so we did a report a couple of years ago on what those look like, and collected model ordinances, in fact, that spoke to that issue. One of our most popular download publications that we did 8 or 9 years ago was conservation thresholds for land use planners. There are a lot of land use planners that are working on trying to say, well, how wide should my stream buffer be? Or what is a wildlife corridor? Or if I'm requiring retention of trees, how many trees do I need in a given area? And the scientific literature helps give at least threshold answers to those questions. And this publication has been downloaded tens of thousands of times by planners across the U.S. and internationally. We also have a book series. One that I did 10 years ago was Nature-Friendly Ordinances, looking at local governments' means of protecting their own environment through land use ordinances. And then a whole series by law professor John Nolan at Pace Law School in New York. And there's an excerpt from Open Ground in the materials for today's seminar, which gives an idea of the range and the ways in which things like zoning ordinances and subdivision ordinances and tree protection ordinances can deal with environmental issues in a way that the familiar EPA and Interior Department and Department of Energy rules and regulations do not. So it's a wide field. I'm going to try to give you an overview of what goes behind land use regulation. I've been teaching land use law to planning students as an adjunct professor for the last 8 or 9 years at Virginia Tech's Northern Virginia campus. So there's a great deal of interest and demand in understanding the intersection that we're going to talk about. So let's start with what's the basis for land use law. And the basis really derives from our common law heritage that we derive largely from England on how owners of land deal with one another. And the two strands that are most important in the development of land use law are the law of nuisance. What am I doing on my land that makes your use of your land obnoxious or untenable? That I've run a slaughterhouse and the fumes make your home uninhabitable. You would have an action for nuisance at common law hundreds of years ago, and land use law derives from some of those same ideas of nuisance. And the other thread is the part of property law, which says what are your legitimate expectations as the owner and occupier of property, one of the most important of which, and you lawyers in the audience will remember this from first year property law, is the right of quiet enjoyment. So the idea is that you can enjoy your property and its normal legitimate uses undisturbed, and that the law will protect you in some way in the quiet enjoyment of your property. Well, historically, the way those rights were vindicated at law were property owners filing suit against one another. You polluted my well, you made my quiet enjoyment impossible, you logged your hillside and it washed out and took out my field or whatever. But over time, it became apparent that government would need to get directly involved, and there were land use ordinances at least dating from the 16th century in England, and in fact in the 17th century, the first century of European settlement in the United States. We also had land use ordinances of various kinds. So the idea that government land use regulation is new or innovative is not the case. We have a 400-year history, but the scope or scale of that regulation has certainly changed over years. And the basis for that land use regulation is what we refer to as the police power. The police power are the inherent sovereign powers of, in the U.S. system, state governments to adopt regulations for the protection of, these are the big four, which have become the big three later, but the four are health, safety, public welfare, and morals. And to some extent, we still have local ordinances that are dealing with morals, dealing with regulation of adult-oriented businesses and drug use or those kinds of things. But to some extent, it's become more comfortably subsumed under health, safety, and welfare, public welfare being a pretty broad category. So there's that inherent sovereign police power of state governments, and then there is the constitutional powers of both state and federal government. The state constitutions define the powers of the state governments and give certain powers in many cases to local governments, or define property rights, or define obligations of one kind or another, set out things like public trust rights in natural resources, or waterways. And then the national government, the federal government, the Constitution creates a federal government of limited powers. It has the powers that are defined in the written Constitution. So the federal government does not look back to inherent sovereign powers. The powers are derived from the federal Constitution. But those turn out to be very broad powers indeed. So land use laws, you will encounter it or have encountered it in your own life, is largely carried out by local governments. Cities, towns, townships, boroughs, counties, and the like. So we tend to think about land use law as what if you're in an area that has zoning, and most of our urban areas do, what does the zoning allow? Is this a single-family district, or does this allow apartment buildings? Or can I put up a 7-Eleven on here if I have enough money to do so? We don't tend to think of the states as engaged directly in land use regulation, but it's really a historical artifact of how land use regulation grew up, that it's happening at the local level, because the powers of the local governments under the U.S. system all derive from the states. So the local governments are regarded at law as creatures of the state that have the powers that state government, in the exercise of their inherent and constitutional police powers, confer on the local government. So if the local government has zoning power, it's because the state has conferred zoning power on the local government. And this becomes important when we look to, is the local government action legitimate or not? Does it violate a constitutional provision or a state provision? We look at the state law and state constitution to determine, is the local government exercising its land use powers in conformance with those constraints? Now, even though I say local governments are creatures of the state subject to state law, the powers of local governments are actually they come in different flavors in the different states. And I'm going to oversimplify drastically by giving you the two extremes of that. And the two extremes of that are states that recognize local governments that have a system of home rule, where the local government has a great deal of independent power, originally conferred by the state by law or constitution, but once having been conferred, being exercised within a very broad swath of discretion. So on the one hand, home rule states. On the other hand, something we call Dillon's rule states, named after a state Supreme Court justice who wrote a land use law treatise in the 1870s or 80s that became famous. And Dillon's rule is basically that local governments have only those powers expressly conferred on them by state law, and those powers that are necessarily implied by those express grants. So even Dillon's rule states there are some implied powers, but they've got to be necessarily implied by the express powers. Home rule states it's sort of like you have a home rule charter under our state constitution, you're free to regulate in all sorts of ways, and we're not going to get into those. There are various classifications of which states are Dillon's rule states and which states are home rule states. Most states are kind of a mixture of each. There are many states that purport to be Dillon's rule states but have pretty loose case law on what powers are necessarily implied. Virginia, my home state across the river, is one of the stricter of the Dillon's rule states. So if you want to change the payday of local government employees from one day to another, you have to go to the Virginia General Assembly to get the power to do that. So local governments are constantly going hand in hand to Richmond in order to get that, because Virginia enforces the Dillon's rule approach very strictly indeed. Home rule states, there aren't any pure home rule states. New York has a pretty robust species of home rule. There are states that have provisions for home rule that they have some that are home rule and some that are not. Maryland allows home rule, and a number of our surrounding jurisdictions in Maryland have home rule powers. Pennsylvania, Ohio have some of those same things. But when you ask, can my local government do this, one of the things that's interesting to know is, did the state government confer these powers on them? And if they didn't confer them expressly, are you in a home rule state or a Dillon's rule state, or is it sort of a mixed picture? So that's kind of the set of flavors of local government power that we're dealing with. And that brings us to the third item on the outline, that the authority of local government, even in home rule states, is usually defined by a state land use planning and zoning enabling act. And that sets out the rules under which local governments can adopt zoning rules, subdivision rules, what provisions need to be in comprehensive plans, who exercises the power that's conferred. So your initial look, if you're looking at a local government, you're advising a local government, or you think you may want to battle a local government, is this exercise of the police power something which is authorized or is in conflict with the state land use plan zoning enabling act? Interesting piece of history. We don't have much federal land use law directly, but in the years preceding and immediately following the First World War, 100 years ago now, it became apparent that the larger cities and even the smaller cities were having more and more of these conflicts between and among uses. You know, when can you put a factory in a residential neighborhood? Can you control the growth of apartments or tenements or the heights of buildings? Or what if your fire department only has ladders that will reach 6 floors? Can you prohibit a 10-story building and the like? And part of the whole progressive movement that led to a lot of the regulations that began in the first part of the 20th century, that gave us the first tastes of product regulation, safe food and those sort of things, also gave rise to this idea that we could systematize land use regulation. And so the Commerce Department, there's no EPA back in those days, the Commerce Department, which was headed by Secretary Herbert Hoover, who later became President of the United States, Hoover's Commerce Department thought, well, we don't have any power to regulate, but we could get the best legal and planning minds together, and we will write a model state law for zoning. And so Hoover's Commerce Department wrote a model standard zoning enabling act with the idea that they would then print thousands of copies, and it would be available to state legislatures, and the state legislatures would enact this, and then that would give the cities the powers that they need. And that was needed at the state level for the reasons I've just said. If you're a Dillon's rule, and almost everywhere was at that time, unless the state law says the local government has the power, the local government doesn't have the power. So the Standard Zoning Enabling Act, early 1920s, tremendously influential. So if you go to any of the 50 states today, you will find language in there that is derived from that act. That the public health, safety, welfare, and morals, that's there. There are requirements that you're zoning in a certain way, and the zoning carries out a comprehensive plan. Where did that come from? That came from the Standard Zoning Enabling Act. few years later, they realized they hadn't dealt with the planning aspect. They'd said you have to have a plan. They hadn't said what had to be in a plan, so they wrote a Model Planning Act as well. And again, it's just the power of the influence or the informational power of the federal government. There was no requirement or direction, or the federal government was making anybody do planning. It was the power of persuasion and governance. So the land use system that we're dealing with, in the U.S. at least, is primarily a legacy of a century, or a little under a century, of experimentation and amendment of those 1920s models that were adopted. Moving on to item 4, it's important to note that in addition to the authority conferred by the state zoning, planning, enabling acts on local governments, anything that's done to regulate land use has to be consistent with the state and federal constitutions. And because federal constitution, supreme law of the land, state constitution defines what the powers of the state government are and the local government. So if you're in conflict with either of those, your exercise of land use planning power is not going to hold up under a challenge. Among the important collisions that we have, or issues we have to deal with in land use law, are issues of First Amendment. Can I prohibit churches from industrial zones? First Amendment issue. Maybe I can, maybe I can't. Can I regulate the content of signs? Probably not the content. What about the size? Can I put signs in a certain zone? Can I require them to conform to a certain set of requirements? Can I make you take down campaign signs from individual yards? Or is that infringe so much on the First Amendment right that I can't? Well, if I can't, how far can I regulate them without running afoul of the First Amendment? And we have the same kinds of issues under the Fifth Amendment on due process and the prohibition on uncompensated takings of property without just compensation. Does my land use regulation take property without just compensation? Now, Fifth Amendment doesn't apply directly to the states or local governments. It applies to the federal government, but the courts have held that the 14th Amendment, which does apply to states and local governments, incorporates the protections of the Fifth Amendment. So if we have property rights claims against a city or a township or a county for a taking of property, an alleged taking of property, it's arising under the 14th Amendment. So when is a land use regulation invalid under the 14th Amendment? Well, there's case law that speaks to that issue. Goes primarily back to a case also from the 1920s, Pennsylvania Coal Company versus Mahan, which the shorthand is if a regulation goes too far, it may result in a taking. And we've been struggling for the subsequent 80, 90 years as to when too far is and what the rules are. And there's a whole wonderful set of cases that we can get into, and I'd be happy to discuss later, but I'm not going to do takings law or just compensation unless we have a lot more time than I think we do to get into that. But certainly local governments and states need to be cognizant of these constitutional provisions and limitations when they write ordinances or provisions into their land use regulation. Due process provisions also apply, and due process also comes in a number of flavors, but among the due process flavors we're concerned about is the way in which land use regulations are adopted, and then whether there's any opportunity to contest them or get a hearing on an alleged violation. And there are processes that I'm going to talk about in a few minutes. But there are constitutional dimensions to, are you being treated fairly, or is there an opportunity to seek redress, and is that opportunity one which gives you the process to which you're entitled under both state constitutions and the federal due process provisions. So all that is prologue to what's the heart of land use regulation. And the heart of land use regulation is the adoption by local governments of comprehensive plans. They're called master plans in some parts of the country. But it amounts to the same thing. And the idealized hierarchy is that the community governing board, the elected body, will adopt a master plan or a comprehensive plan which will lay out a vision for the community. And that vision for the community will take into account existing land uses and future land uses and accommodations for growth. And depending on what the state enabling law says, there may be required provisions for a comprehensive plan. That it has to have provisions in it for transportation or economic development or protection of natural resources. And most of those state enabling laws have mandatory elements, and then many of them also have discretionary elements. Plan may also contain provisions to protect watersheds, aquifers, scenic beauty, historic preservation, whatever. And again, you have to look at the state enabling law to understand what those comprehensive plans or master plans might have in them. So then, having adopted that, you're then entitled as a local government to adopt a zoning ordinance. And zoning has been much criticized in the many decades since it became the standard, but it's still the predominant form of land use regulation in the U.S. And by it, the local government defines zones under which certain land uses are authorized and where they are not. So our most typical sort of zoning things is this is residential, this is commercial, this is industrial. And then, okay, so are these completely exclusive, or are there different kinds of these, or are there circumstances in which you can have commercial activities in a residential zone? And the questions for that are determined in part by the State Enabling Act, and then within the State Enabling Act, determined by what the local government has written into its zoning ordinance. And the zoning ordinance has to be in conformance with or in accordance with the comprehensive plan. So if you have a comprehensive plan that says one thing and then you write a zoning ordinance that says something completely different, it's not valid. It violates the state enabling law. It has to be in accordance with the comprehensive plan. If you never wrote a comprehensive plan, it can't be in accordance with it. There are a few cases that work their way around it, but it was mostly before people got wise to the idea that, you really do write the comprehensive plan and then the zoning ordinance. And then the zoning ordinance usually has this long list of uses and requirements and provisions that say, okay, it's a residential zone. How many houses per acre? Are they multifamily? Are they single family? Do they include apartment buildings? And the zoning ordinance may have requirements for front yards and side yards and setbacks and those sorts of things. So the zoning ordinances get extremely detailed. They may say, can you have a garage? Can you have several garages? All kinds of things end up in those ordinances. And then the next level down is subdivision regulation. Subdivision regulation is basically the set of rules that deal with subdivision of land. So if you go back to imagining the unsettled area that's just been taken over by European settlers, and to their point of view, it's all owned by the king or by the state government who's succeeded to those powers, and I now have 1,000 acres that I've just gotten from George Washington. What do I want to do? I want to subdivide it so I can sell individual lots. Well, it's helpful to have rules for that, like how do we keep track? So the original subdivision laws, state laws, said how did you document that, and then where did you record it? And even today, you record it generally in the county courthouses in those books or databases which deal with subdivision. But over time, there became the idea that it's important to have rules about subdivision. You don't want people subdividing lots into lots that are so small you're going to have shacks or tenements, or that's all that one could build. And you don't want to subdivide where somebody subdivides in such a way that it leaves parcels landlocked and completely unusable because they have no access to a public street or public way. So subdivision ordinances then began to incorporate all these rules for the size and configuration of the lots, as well as how you document and record subdivision. And then over time, subdivision ordinances begin to get into things like, now when you file your plat for subdividing the property, we don't want you to include this waterway because it's not buildable, and this waterway can't be counted toward the buildable amount of the lot that you're supposed to have. So, you know, you may be able to count it in part toward the acreage, but not toward the buildable area. And so you can't just lay a grid out. You need to take into account the requirements that the subdivision ordinance have for those areas that you exclude or that you have to treat differently. So subdivision ordinances then became the vehicle for including certain kinds of environmental and other provisions, like retention or reforestation of areas, or things dealing with transportation access. So anyway, the hierarchy would look like you have the grand plan, and then you have the zoning ordinances which say where you can do things and to some degree how you can do them, what they're shaped like, and then you have subdivision, which gets really into the fine-grained detail. But in fact, the evolution of the law was exactly the opposite. We had subdivision laws first, then we had zoning, and then we had planning. So you have sort of this Platonic ideal, and it's an important one to keep in mind because we're supposed to have that ideal of planning, zoning, subdivision as a way of keeping track and making sure things are in conformity and work properly. But if you wonder how did these things get to be the way they got, or why is this in a subdivision ordinance rather than in the plan, it may be an artifact of history as to why these things developed or how they developed over time. So keep track. Land use professors teach it both ways. I was a history major. I like to look at the kind of historical evolution which explains for me why a lot of anomalies exist. Others like to have the orderly system that you can explain because that's how it's supposed to work. Both of them are true, and I hope I've at least introduced you to what that looks like in these few minutes. There are other regulations and ordinances that the excerpt from Open Ground that I put in the materials give rise to. Many of them are included as parts of zoning ordinances. They're types of flavors of zoning ordinances. There are others that the local governments are doing under their police powers, like can you have backyard chickens? You know, that prohibition may be in the zoning ordinance, but it may be in an ordinance that is entitled keeping of animals or domestic animals or whatever it may be. There are requirements or provisions that may deal with hillside protection or tree management or tree replacement or historic preservation. Those might be in the zoning ordinance, but they might be in some other police power ordinance of the local government. So you need to look at a number of places. When my kids were young, it's kind of like, can we get such and such a pet? And I would always say, well, no, hedgehogs aren't allowed under, Arlington County rules. And one of my daughters went and looked it up, and she informs me that, yes, they are, or at least they're not expressly prohibited. So maybe that's the case. She tells me they are excluded in Fairfax. I don't know. I've never bothered to hunt this down because I'm not having a hedgehog in the house. But certainly these kinds of provisions are things that will occur as land use regulations as opposed to what you might think of as environmental regulations, even though they might have a great deal to do with what the quality of life is in the area that you're dealing with. And we're getting into this now with the interest in community and backyard agriculture and disputes over keeping of hens and things like that is just one flavor of those things. The whole concept of zoning in the 1920s bothered people because it was an infringement on property rights in a way. It's kind of like you're telling me what I can do with the property that I bought and paid for, and I have these great plans for, and where do you get the right to do this, state government or local government? And even if you think you have this right, doesn't that violate the 14th Amendment? And the landmark case, since the one you'll need to know if you have any interest in this area at all, and it's a foundation for U.S. land use law, is the City of Euclid versus Ambler Realty, a 1926 Supreme Court decision, where the Supreme Court upheld the validity of zoning, a fairly sophisticated form of land use regulation by the town of Euclid, Ohio, which separated out single-family and residential and multifamily apartment buildings and industrial uses within the town, much to the dismay of the investors and owners that had other plans. And the court hearkened back to the ideas of nuisance law. They said, we're not relying on nuisance law, but nuisance law is sort of a guide to why this exercise of the police power is valid and doesn't violate due process rights. And so Euclid then became the touchstone for, yes, zoning land use regulation is valid. It doesn't violate the 14th Amendment. That hasn't obviated other claims. There's plenty of land use litigation, a very active area, but the claims tend to be on other grounds, including direct takings claims, which are not foreclosed by Euclid, and then other claims that are frequently based on violations of the state enabling law. But remember Euclid, 1926, that'll get you started as a land use lawyer in your discussions with your environmental colleagues. The other thing I want to mention, and this is number 6 on the outline, is administrative processes, and these are important. I often talk about land use law as a way in which we take advantage of the main function of law, which in my view is we settle disputes among people, and the law provides an orderly way to resolve disputes. Under the oldest system, right, so we think back to the mysteries or the history of medieval time, someone's infringing on your quiet enjoyment, you just hire a bunch of people and challenge them to a duel or whatever it is, and you settle it by combat. That doesn't work too well, so then we evolve to you have private litigation. You've committed a nuisance, court issues an injunction. It's all the Blackstone stuff. Well, we don't want everybody suing each other. Can we have a 7-Eleven on the corner? Are your chickens okay? Can I put an extra story on my building? So we set up this system of rules, and the rules do hit people in different ways. Supreme Court in Euclid says, yeah, that's the way law works. We set up a system of laws which are designed to resolve in an orderly way disputes which we know are going to arise, but they won't affect every landowner, every individual the same way, but that's the way law works. And if it's really egregious, there may be mechanisms to deal with it. So who do we want setting those rules? Well, who we want setting those rules, at least under the U.S. system, has been the local elected governments, closest to the people. Who has the vision of the community? The elected county board of supervisors, the elected town council, whatever. They may need the insight or expertise of another body, a planning commission or board, which can draft plans, and that those then will be presented for adoption. And then zoning, which is the law that actually applies to individual conduct, that's adopted by the elected officials because they're the ones entrusted in a democratic system with the power to make law. So this ends up being a local government function administered to a pretty large degree by elected officials. So if you want to rewrite the zoning map, it takes a legislative act to do that because they're the ones with power to do that. So you want to rezone property. You have this great idea, it's a residential area, but it's near a metro station, and you really would like to put up a really large apartment or condo building with mixed use. You end up going to your board of supervisors or whoever, and you request amendment of the zoning map in order to get what you think you're entitled to. You're not entitled to that as a matter of law, because your use of the property, you still have a current valid use of the property. So you can't compel it, but you can persuade them to do that. And sometimes that persuasion takes the course of persuading enough people to vote for the people on the board that, like your particular vision of the community or whatever. And that's why people express concern about, are developers too close to the elected officials? And it's kind of like, well, the elected officials are the ones setting the rules by which landowners and property developers are making the rules under which they can derive value from the property. So, yeah, of course they'll do that. But there are rules for that, like not just rules on can't do bribery and so forth, but rules under which these activities can be carried out. You can't have a surprise meeting and then rewrite the zoning ordinance, zoning map. It has to be advertised. So people have the opportunity, at least in theory, if not with influence, to say, this is a terrible idea because, because why? Well, the soil's unstable under the area, or because this other factor that you haven't taken into account is going to have effect, or because if you approve a condo building, it's 11 stories high, it'll shadow the solar panels that our neighborhood just put up, whatever that is. So there are sets of rules that the state laws set up, which then the local governments adopt and can expand on for how you make these legislative decisions in an orderly, accountable way. Now, there are other kinds of disputes that arise with mere administration of the zoning ordinance. So somebody, I build a 7-Eleven on my residential property, And so the code enforcement officer comes out and gives me a cease and desist or an order to tear it down or whatever. I don't take that to I don't appeal that to the legislative body. I appeal that to the body that's set up under law that's entitled to hear those, and then I appeal that if I lose to the court. And typically I'll appeal to a state court where the claim that I'm making is based on state law. You know, the fact that they prohibited me from building my commercial use on my residential property, they're not right to enforce it against me because when they adopted the original zoning ordinance, they didn't follow the right procedures. You know, they didn't advertise the zoning ordinance, or they changed it from the way it was advertised. So I have a state law claim, I file it in state court, it goes up through the state to the state Supreme Court, and if it's a state law claim, the state Supreme Court has the final say. You know, that's the case. And we see that not only on the small scale, but you can see that on the larger scale too, of these appeals where there's an action that affects a large numbers of property. The claim might be the proper procedures weren't followed, and it gets struck down. A number of years ago, Loudoun County, fastest growing county in America, was concerned about where that growth was occurring. They adopted a new plan and zoning ordinance, if I'm remembering correctly, which downzoned a certain part of the county to limit development in that part of the county, and certain property owners didn't approve of that, and they challenged that legislative act and took it up through the Virginia courts. And ultimately, the Virginia Supreme Court, if I'm remembering correctly, determined that that the Board of Supervisors had not followed the proper set of procedures because while they had advertised an ordinance and they adopted an ordinance, there were enough changes in the one that they adopted that the first set of hearings was not sufficient notice to allow that to take place. So that meant that the zoning ordinance which was adopted was invalid because of a procedural mistake, which was up for grabs. Anybody dissatisfied with that view, there's nowhere to go from the state Supreme Court because it's an issue of state law. Did they follow the right procedures? Yes, they did. No, they didn't. And the same thing occurs with all sorts of other disputes. One of the things that land use law provides, and that many of you may have heard of, is opportunity for a variance. So there's a set of rules that apply, but a variance says if these rules that are of general applicability apply too hard or bite down in an unfair way on a particular property, there is the power to grant, of the local government, to grant a variance where that occurs. Well, the states all have different rules for variances. The strictest rules of variance is you only get a variance if the land use regulation basically makes impossible any viable economic use of the property. That is, if it amounts to a taking, you don't get a variance in those states. In others, and the general language that's used is undue hardship. You'll see undue hardship is the variance standard in almost every state, but the courts have all interpreted undue hardship in different ways. So in the example I described, some courts and states see undue hardship for variance as it's a taking or it's tantamount to an uncompensated taking of property. In others, undue hardship is it doesn't seem to be as good a use as your neighbors are able to make of similarly situated property. And there are a range of variance standards in between. We've had a number of versions of these, and I'm going to go back to Virginia because I live there and because I've been teaching there for some time. 20 odd years ago, I put an addition on the house that I live in Arlington, and I wanted to put the air conditioning unit in the side yard as opposed to behind the house, because I don't really want it sitting there in the back, the backyard. So my side yard, though, since it was one of those old Arlington lots, is not wide enough. I don't have 10 feet over there. I've only got 8 feet. And if I put the air conditioning unit in that setback area, I'm in violation of Arlington County zoning ordinance. So I applied at that time for a variance. And I got all my neighbors, it's advertised as notice. My neighbors all, signed little things I took around saying, hey, I had no problem with that. I went for the hearing. I stood up, asked for the variance. Any objections? Got my variance. Well, a few years later, the Virginia Supreme Court revisited the variance standard, and the Virginia Supreme Court said, that's not the Virginia variance standard. The Virginia variance standard of undue hardship isn't inconvenience. Is it tantamount to making your property completely unusable? I couldn't satisfy that. I mean, my property was usable before I, put that there. I had other places I could put the unit, whatever. So that variance is no longer available in Virginia. Smart land use lawyers rewrote the zoning ordinance to come up with other ways to accommodate situations like the one I'm describing, using terms like conditional use or permitted use and so forth, where you have to make a showing, but it's not a variance, which is something that you're entitled to get. So that's kind of a one extreme, and in this short time the 20 odd years I've been where I've lived, the state law was interpreted in two different ways. The language of the law didn't change. So that's my other lesson, is you look at appeals and regulations and judicial review. You got to look at the case law, not just at, superficially what do the provisions of the ordinances and land use laws provide. I think I'm gonna pause there to see if there are any questions on this overview before I get into some more particular issues. I don't know if there's anything from the phone, but anybody that has a question there can send those in. Anybody in the room got a question based on the sort of quick tour through almost an entire semester of land use law in an hour? Yes, you in the front?
Yeah. How does, you might be, I don't know if you're covering this later, but in the hierarchy of like state, local, municipality regulation, where do like regional organizations fall, like the regional transportation organizations and things like that?
The question is, in this hierarchy of state and local land use regulation, where do regional bodies fall, specifically including regional transportation organizations like metropolitan planning organizations that have a lot to do with how federal transportation dollars get spent. And I will defer that for a few minutes. The next topic I'm going to cover is federal land use regulation, where I'm going to touch on the transportation regulation. I will say that the basic model, though, has been one where it's been primarily a state, local issue, and that where regional bodies have been involved, they've come in at it kind of sideways by influencing the way dollars are expended or by taking advantage of how state and local land use regulations are administered. So there are not very many regional bodies with direct land use powers, although there are a few, like the one around Lake Tahoe. in California, about which there's a lot of interesting litigation. One of the questions from the phone are, what are some of the most admirable examples of comprehensive or master planning? Wow. And what states or counties are the leaders and innovators? I don't want to opine on admirability, and I'm going to miss a lot. One of the places that you can look for this, though, is the Environmental Protection Agency has an Office of Smart Growth, which administers Smart Growth Awards. And if you look over the last decade of Smart Growth Awards, you will find a goodly number of communities which have engaged in use of their land use laws in environmentally beneficial ways. And those have included both very large jurisdictions and neighborhoods or boroughs. Leaders and innovators include some in this area. Arlington County, where I live, has been did win one of those national awards, but has also been recognized as an innovator in transportation planning, in particular, and concentrating growth around metro corridors and the like. Montgomery County, Maryland, done a great deal with protection of the western part of the county as an agricultural preservation area. They pioneered a land use technique called transfer of development rights that I'm going to talk about a little bit later if I have time as well. In the states, I'm going to touch on this too. There are a dozen or so states where the state law has been a lot more directive about not just saying, here are the rules for planning, adopt a comprehensive plan and adopt a zoning ordinance that is in accordance with the plan, but also require things like figuring out whether there's enough water or transportation or protection of open space. And among the longtime leaders in that area have been Vermont and Oregon, Washington to some extent, Maine, and there are some others that I think I'll touch on as well. But there's a great deal of innovation out there. I'll give you one more reference. Actually, let me think about this for a bit, because there is one of the other places you could look at, and an organization I admire quite a bit, is the American Planning Association, which is the professional organization of planners around the U.S. and the world. They have something on the order of 20,000 member planners from all over this country, and put out some really wonderful publications through their planning advisory service. So the APA also gives out annual planning awards, and while not all those are direct land use regulation, some of them would respond to this question. It's a question, what are some ways state or local governments measure the effectiveness or impacts of land use planning? What are best practices in metrics? I don't know the answer to that question. Measurement has been a little bit difficult, partly because you can't always predict where people are going to want to move or live, or you might have a great plan and then there's an economic slump, and is the problem it's not a good plan, or the land use or the zoning rules are too strict, or is it simply that the economics don't work anymore in this area? Some of the standards that get used for metrics are looking at density, walkability. There are some organizations that do walkability scores now. I have found those to be modestly useful, although the places that I know well, I never seem to conform, their score never seems to conform to my experience in both directions. But it is a good, it can be a good metric. There are areas that talk about miles of stream corridor protected or acres of farmland under conservation easement. So those numerical metrics can be good, but the metric, is this a happy, healthy community doing what it wants to do? There have been some attempts to do that by sustainable cities organizations, and I just don't know how well that has fared, and others in the audience may, or we can circle back to that if there's time. I think there's one more that I have from the phone. Can you talk about the intersection of land use law and environmental justice or social justice? The law can be used to support or frustrate social progress as well as environmental sustainability. Could you share your experience and an example or two? Yeah, it's very interesting. The land use law can be used and has been used to lock in preferential patterns that the powers that be already like. So it's been used for large lot zoning that poor people can't afford, and to keep out apartments, or to keep out transportation that that would have access by poor people. Or some towns have used it to keep out all commercial development and then all the commercials on the neighboring town. Others have grabbed all the commercial development and kept out all the low-income housing. And that the ability to do that has actually been an area of great litigation over the years, and there's a very interesting line of cases in New Jersey where the New Jersey courts basically went after the towns for deliberately zoning out low-income and minority residents. Whether or not that line of cases actually has made things better in New Jersey is hard to judge, because there's still a great deal of separation by income and race. But certainly land use law and legislative law has been enlisted in attempting to deal with that set of issues. Environmental justice, same kinds of issues. That the environmental justice has tended to separate noxious industrial uses from large lot, single family, upscale housing. It hasn't tended to do that in all cases with lower income housing. And then you do have access issues too. What happens if all the jobs move to the suburbs? What do you do with transportation? And there, land use law really should be speaking to transportation planning and making multimodal access a lot easier than it is. And it's a fraught area, but it's not one I feel like I can do justice to in this short amount of time. Because land use law shapes our communities and economic development, and in many ways guides our public infrastructure money, if you care about environmental justice and social justice issues, you're going to do a lot of good focusing on land use law, and maybe more good than focusing on the Clean Water Act or the Clean Air Act or the RCRA, as important as those are. I'm going to ask if there are any more in the room before I launch into the rest. Yes?
I'm from Mexico, and I'm seeing that the land use and everything is quite similar. We also have local governments regulate that and everything. And in the practice, I'm thinking about the problems that I have to solve with my client and stuff. And there's a big problem in Mexico with the application of the law. For example, if you have a very large ranch, cattle ranch, and then you want to change it and you want to open it to agriculture. In Mexico, that's a very expensive land use change, because we always have people want to change the use of the land that's on the plans. Do you have that problem here in the United States?
Yeah, so the question for those of you on the phone is from a practitioner from Mexico who deals with lots of issues with changes of land use and gives the example of a desire to change a large cattle ranch into subdivision or many smaller agricultural plots.
To change it, like, for example, to open it to agriculture. When you
Okay.
want to change a soil
Right.
from cattle,
Yeah.
you want to, what do you say, to put seeds or to
Yes.
agriculture, that land, you have to open it, and it's a quite environmental damage to open the land. And
Okay.
we have like thousands of acres daily open to agriculture. Do you have this problem in the US?
So this is conversion of
Yes.
large ranches to agriculture. And we don't have precisely that issue in the U.S. For the most part, a lot of land that is already suited to agriculture is already open to subdivision without a lot of protection. Most of the large agricultural areas, there is not agriculture. Agriculture is sort of the default use in most of the U.S. So there are some areas in the east and in urban areas where there is agricultural zoning which doesn't want the farms to get smaller than 100 acres or 50 acres because they'll no longer be useful for agriculture. But we very rarely have a situation where you have a large ranch which is suitable for these other kinds of uses that there's much difficulty in changing it. In the West, we do have large ranches that are changed to often for building very large subdivisions, and that's typically governed by the state law and then the county, typically the county laws, which allow that. And the general norm has been that counties have been willing to rezone those because they regard it as a more lucrative use for the tax base and advantageous to the developers. Sometimes for conservation reasons, conservation groups have opposed those land use changes, and sometimes there have been instances under which cattle ranchers also have entered in granting conservation easements over large areas of the ranching area to keep it in ranching while allowing a small part to be subdivided for use. So there are a lot of solutions, but our large kind of open areas tend not to have a lot of pre-existing land use regulation. And so often the first land use regulation occurs after that demand for the change has occurred. We can talk further if I haven't really answered your question, I think. Anyone else in the room before we go on? Okay. So I'm going to move on to item 7, and that deals with federal land use regulation. And it's sort of customary to say we don't do land use regulation at the federal level in the U.S. We don't have, as some countries do, a federal land use planning law. Many countries do, and they come here and they want to talk to us, and they're amazed at the fact that we don't, at the federal level, prescribe where you're supposed to put electric power plants or what areas are appropriate for, this use or that use. And that's an artifact of our history as a decentralized sort of state-led kind of governmental system, as opposed to a very strong national government at the federal level. There are, however, federal laws that do speak to uses of land. One of them I alluded to at the beginning of my presentation when I mentioned my career. When I started in Interior Department, one of the laws that had been passed in 1977 was a federal law regulating how coal mining was done. Well, that's a regulation of a land use in a way. That says if you take the coal out, you have to put the land back in its approximate original contour and restore the topsoil and plant things on it, have a post-mining land use, post a bond, all these good things. And a number of the states and the coal mining interest filed suit in federal court claiming that this amounted to federal land use regulation, which, as everyone knows, violates the Fifth Amendment and the Commerce Clause, and the 10th Amendment to the Constitution, which reserves powers to the states and to the people. And a unanimous Supreme Court held that, no, this was a proper exercise of Congress's commerce power, because coal moves in commerce, and regulating how coal is extracted is pretty important to whether people using bad methods can undersell people using good methods. And also, there's a great effect on water and air, particularly water they looked at the time, because if you're destroying headwater streams and the like, that's destruction of navigable water, something that is within the federal power to address, and uses of the waters. And so unanimous Supreme Court held that form of regulation was not in violation of any of the familiar federal constitutional provisions. But in some ways, that's a little bit of a special case. Another somewhat special case is the federal power over the federal domain. About a third of the nation's land is owned outright by the federal government. And as owner, the federal government can make the rules for how those lands are being used. And a lot of those lands are ones where cattle ranches occur, but they occur on federal land under grazing leases, or there's coal mining or oil extraction under mineral leases. Or sometimes there's mining under no leases at all, but under the 1872 mining law, but which allows occupation of federal lands under certain conditions prescribed by law and regulation. But because the federal government owns that outright, the federal government can make the rules for the uses of those lands, and they do. So if you want to know what you can do on forest land, you look at the Forest Service's regulations, or Bureau of Land Management land, BLM regulations, or the like. The same applies to the territorial sea, the lands offshore of the United States under federal jurisdiction, and federal government makes the rules for how those lands are being used. State jurisdiction goes out 3 miles. The feds have everything after that, and so when you're looking at as we have this week. Is there going to be drilling offshore of the Atlantic coast for oil and gas? That's a decision committed to the federal government under federal law, and it's governed by the Outer Continental Shelf Lands Act and regulations, and then other applicable federal laws, Marine Mammal Protection Act, NEPA, all those great public lands and waters laws that we're familiar with. Now, in addition to the direct controls, there's also federal influence over state land use planning and regulation. There was interest in the late 60s and early 70s in let's get a handle on the environment, and that's when we got the Clean Air Act and the Clean Water Act and the Endangered Species Act and NEPA and pretty much all the laws that we know and love today. There was also a move afoot to have a National Land Use Planning Act. It did not survive, but part of it survived in the form of the Coastal Zone Management Act. And the Coastal Zone Management Act doesn't directly regulate private and state lands on the coastal zone, but it made a bargain, in effect. It said, states, if you adopt plans for the management of your coastal zone, and you adopt enforceable laws and policies that apply to activities in your coastal zone, we, the federal government, will make all of our actions consistent with the state coastal zone management plan. Federal consistency. So the federal government says, you guys do the plan, it'll meet certain standards, and we'll give you a bunch of money if you do the plan and carry it out. So a little incentive. And as further incentive, if you tell us your plan doesn't allow us to put our jet port or our natural gas facility there, whatever it may be, we will abide by the enforceable laws and policies that implement your plan. So the Coastal Zone Management Act does provide some level of incentive for land use planning at the state level and enforcement, which binds federal actions which the federal government might otherwise take, without taking those issues into consideration. It's not terrifically strong. There are circumstances like national security under which those can be overridden, and also the state needs to be careful what it writes in its enforceable laws and policies, because if it doesn't write them carefully, the feds will say, yeah, you tell me you don't want liquefied natural gas there, but there's nothing actually in your enforceable law or policy that says I can't do that. Then there are ways in which these things get sorted out. But there is some element of federal influence. Another area is the area that we alluded to a few minutes ago, regional planning of some kind or other. And the most direct of those is the way our federal transportation dollars are administered. And those basically set up a system where metropolitan areas, through bodies known as metropolitan planning organizations, go through and figure out their land use planning and transportation needs and aggregate those, figure out what transportation projects are needed and which ones are fundable within the amounts of dollars that are reasonably predicted to be available. And that will drive where the federal transportation dollars go. So there's sort of a bargain going on there in a way by encouraging planning or at least aggregation of transportation wish lists by regional bodies to determine how federal money is going to be spent by the states and local governments. There's also a crosswalk because of Clean Air Act provisions where those plans need to take into account effects on air quality. And so in effect, we're asking the Metropolitan Planning Organization, state transportation planners to do some clean air planning in terms of the land use projections and transportation demands and projects that they anticipate. Clean Air Act definitely influences land uses and land use plans, and I'm not going to try to do any of the Clean Air Act since we had a session on those before, but whether you're an attainment or non-attainment area does make a difference for what kinds of uses are able to be permitted in your area, and this will become increasingly important in the years ahead. The Clean Water Act, because of some amendments in the 1980s dealing with stormwater, imposed a great many requirements for control of urban stormwater runoff from construction areas and city streets and urbanized areas that are driving and influencing a lot of the trends that we're seeing, like green roofs and daylighting of streams and retrofitting. And so the Clean Water Act is, to some extent directly and some extent indirectly, influencing what people that are engaged in land use planning and capital improvements planning are doing for local governments. And the Endangered Species Act is on my list as well, because that can affect uses in a significant way. You may have no zoning at all in the area that you have, or the zoning may permit the use that you want, but if you're going to kill the bog turtles or the Preble's jumping mouse, or you're going to have to deal with the Fish and Wildlife Service in order not to be at odds with federal enforcers. But if you anticipate a kind of system, as some do, from much more centralized administration, and you expect to see the federal system and the state system and the local, we don't have it. And in fact, most of the states don't prescribe uses by geographic area or whatever. They leave it entirely to the local government, with the exception of the dozen or so states that I alluded to, of which Vermont and Oregon are probably the strongest examples. I'm going to say a little bit about types of land use regulation, and the Open Ground Book excerpt that I put in the materials will give you a short list of those, and there's a little table on the last page which gives you that. John Nolan is, I think, coming out with another book that ELI is going to put out later this year in this series, so he's got a great series of local environmental regulation using these tools. One is Euclidean regulation, so-called Euclidean, not just because it's geometric patterns like Euclid geometry, but the city of Euclid versus Ambler Realty, which said designing areas where certain uses are permitted and others are not, and prescribing densities and heights and so forth. This is the way we do it. And that system was one that was based originally on separation of uses. It turns out that separation of uses sometimes produces effects that you don't want. It produces solely residential neighborhoods, and then the Walmart commercial strip area, and you have to drive from one to the other, and that's not necessarily good. So there are zoning ordinances which provide for mixed uses or permeability of these zones, and there are many, many ways to write these. Another approach, which is particularly useful in the environmental context, is overlay zones. That is to say, we have our Euclidean map, what you can do and where, but we know that there's a particular area that's a migration corridor, or it's a flood zone. Actually, flood zone's another federal influence on land use planning that I didn't cover. But there's an area which is of concern, like the wetland buffers in the first report I held up. One of the ways to protect that is not to say this is a wetland zone. We probably don't want to do that, because if it encompasses people's entire property, it might raise some takings concerns by the property owner. But we can overlay that wetlands area over the various commercial and residential and industrial uses, and we apply special rules within that overlay zone. So you comply with both sets of rules. Single-family home at such and such a density, setback is larger, or you don't mow the area which is in the overlay zone to protect the creek. So an additional set of rules. It works as an overlay. I guess we still think of overlay. And when they invented these, you had plastic mylar sheets that you had the zoning map, and then you put another sheet down, and now you just have another layer of your GIS, which shows you that. Growth management, I've alluded to, and a number of states have gotten into having people having municipalities designate their areas of growth and conform with some state or regional goals. Maryland did this in an interesting way with their Smart Growth Act in 1997. Still pretty interesting, which designates priority development areas. And if development occurs in priority development areas, it's easier to get state funding to support infrastructure. And certain things are easier to do. They're not prohibited in those areas, but it's a way of influencing the ways in which local governments make their decision about their own zoning maps. Buffers, I've alluded to. I want to touch briefly on TDRs, PDRs, transfer of development rights. So typically when you would set up a zoning district, it would have a density, and that's what you're allowed to build there. Well, there are other areas where you really don't want people to build, and the question is, well, are you taking their property if you say, no, you can't build in any of this area on the steep slopes around Lake Tahoe or in the agricultural district of Montgomery County, Maryland, what do we do in order to make sure these people get some economically viable use out of their land? Well, one of the things we can do is we can give them a saleable, transferable development right. So you can't build the homes on that protected area, but we give you a certain number of development rights, and then we have other zones where if people want to build more densely than the rules permit in this other zone, the receiving zone, they can do so if they have enough transferable development rights. So the developer in the receiving zone says, oh, I could put a lot more units on here, but the zoning rules don't let me do it. I'm going to go over here to somebody in the farming zone that's got 100 TDRs, and I'm going to buy those. And under the rules then, he or she makes money. I've acquired the right to do by right what I can't do under the existing zoning. I get greater density. I've taken advantage of transfer of development rights. So this was kind of a nifty innovation. It's used in a number of sensitive areas like the New Jersey Pine Barrens and the New York Long Island pinelands. And Montgomery County is still one of the great study areas. And Lake Tahoe, there have been some litigation over that, but including some Supreme Court cases. So just look up Tahoe or Tahoe Sierra, and you'll learn a lot about transfer of development rights. Transfer of development rights were also featured in the Supreme Court's Penn Central case in 1976, which is a very important historic preservation case where the Supreme Court upheld New York City's historic preservation of historic railroad station, partly on the basis that the air rights, which could not be used there, could be used elsewhere in the city. So interesting concept. PDRs is just another flavor of that. There's not always a market for the TDRs. Not always, in my example, the person who says, oh, I want to build much more densely here. So governments have set up either governmental entities or government-influenced land trusts or the like to purchase the development rights and hold them for later sale, or in some cases to retire them permanently, but to do so in a basis which is not quite the same as purchasing, conservation easement, but is done by purchasing these units. So very interesting. Lots of creativity in this field, and oftentimes the case is, when do we use these tools and which tool can we use? And people with a lot of planning staff and funding like to try them all. So in the Washington metropolitan area, local governments here have tried pretty much everything that you're going to want to see, and including some nifty forms of zoning like form-based zoning, where we're not going to tell you the use, but we are going to tell you the form. That gets us out of defining, can restaurants succeed here as opposed to a hardware store or whatever, but does get us into let's have a living streetscape or the like. So lots of innovation in use of these zoning tools. I'm going to say a little bit about critiques of land use regulation. The big critique, and this critique was there from the very beginning, is it locks in a community's vision of, or a particular board's vision of the comprehensive plan and the zoning map. So it can stifle the kind of vibrant, uses or reuses that people want to make. And if it's very hard to get a change in use, areas will just be abandoned because it's easier to build a new area where those rules don't apply. And if it's difficult to get opportunity to reuse an industrial building for loft apartments, well, okay, so it'll just sit there as a vacant industrial building. There are ways to accommodate that, but it does require a pretty nimble local government to be able to do that. So there is that. that concern or fear that if you just write a zoning map and then it sits there, forever, you've pretty much locked in what's going to happen for good or for ill. Many places are content to do that. We moved here because we like it the way it is. We want all the high-cost housing and low taxes or whatever it may be, and we're going to lock it in, as long as we can. And that raises, as one of the questioners did, what about environmental justice or social justice kinds of concerns? There's been a lot of concern with Euclidean zoning, which concerned itself with uses. I mentioned form-based codes. One of the things is maybe shouldn't be that concerned with uses, but with the shape of the building and how it conforms to transportation and the natural environment. And we're not really concerned as to, is this residential or is it commercial or is it mixed or what it contains in it. There are areas of the country that don't use zoning, and Houston is always the example that everyone uses. Houston never got into the zoning deal, so it's got kind of hodgepodges of uses in different places. It does have land use controls, though. In many places, the controls were imposed when the land was subdivided by restrictive covenants, which is kind of land use law, but it's kind of the law of property. It's when we subdivided it, we put requirements in the deeds that said, this property will never be used for an industrial use. Or as in many parts of the country until the Supreme Court declared it unconstitutional, this property will never be sold to any person not of the Caucasian race. Declared unconstitutional in the 40s by the Supreme Court, but persisted for decades afterward, and definitely changed entirely the character of communities. So private, the less pernicious versions of those arise under the guise of homeowners associations. That's not land use regulation that's imposed by a government. It's imposed by the deeds that the property developer wrote in conveying the property. And that may say, all members of the homeowners association will have a well-maintained lawn and will have no accessory athletic equipment in the front yards and no clotheslines or, no flag larger than 3 feet by 2 feet or, and some of these were definitely and are definitely intended to, encourage people to maintain or force people to maintain property to a certain use or not put up unsightly sidings or horrible paint schemes or whatever, but it's a form of private land use law which is enforced not by the government but by the members of the homeowners association against their own members, and it's contractual. So you violated the contract. You didn't violate the law, like in my 7-Eleven in my town. I violated it by hanging my laundry out when my covenants and restrictions in my property deed say, no hanging laundry either at all or between the hours of whatever and whatever. And I should give them their due, but it has come up in environmental situations where it's been hard sometimes to put solar panels up or to engage in people using landscaping of their lawns that doesn't require a lot of water or mowing or whatever. If the homeowners association requires you have a well-maintained lawn and you've got native plants that can put you at odds with people enforcing that through that form of land use regulation. So the other approach is, let's not have land use regulation at all. Let's just see what happened. Works a lot of places. And there are many parts of the country that don't have zoning or land use regulation, particularly in the West and even in some rural parts of the East. And usually there's no demand for it unless some noxious use, like a regional perceived noxious use, like a regional waste disposal, incineration facility, or a very large mine or gravel pit or whatever comes into the area, and then it's kind of like, shouldn't we have anticipated that? And by that time, it's too late, because people may well have the vested rights to do what they've set out to do. But a large part of the country has, not where most of the people live, but a large part of the country has no land use regulation, so it's worth bearing in mind. I was going to, and I'm still going to say a few things about the examples. I know for these summer school sessions, the example that we've been using is this chemical spill, which I'm not going to use because as far as I can see, there's not really a good land use hook. It's located in an industrial zone. It was a permitted use in the industrial zone. And perhaps you could have written industrial zone regulations that required a bigger setback from the river, but you can't really write ones that require inspection at a certain frequency. In many states, it'd be very hard to write something like that. So I actually want to use an actual example, and that is a case that came out last week or the week before, which is the town of Dryden case, which is New York Court of Appeals. It's the highest court in New York. And the question that arose was hydraulic fracturing for recovery of shale gas. Can towns in New York State prohibit it? So we've got a lot of hydraulic fracturing in the U.S. now, particularly in the eastern United States, and we have different approaches. A lot of fracturing in West Virginia, Ohio, Pennsylvania. Maryland, there's a moratorium right now while the state legislature waits for the results of a study commission to write some rules and regulation. New York, there's a moratorium while the state regulatory agency, the DEC, gets to writing rules for that. But the expectation by many is that there will be some form of hydraulic fracturing that might be authorized in parts of New York State. And so a number of towns said, well, we don't want that, so they amended their zoning ordinance to zone out as an industrial use, not permitted within the list of industrial uses allowed in the town's industrial zone. They zone out hydraulic fracturing for oil and gas. Well, is that good public policy or not? Do we want each town deciding whether or not oil and gas can be extracted? Maybe we do. It's close to the local residents. It reflects what they're after. Maybe we don't. It may not reflect the larger interest of the state in a vibrant oil and gas economy and jobs, and not having one town allow it and the next town not allow it, or whatever. So the legislature in New York wrote a law governing oil and gas, which says the provisions of this oil and gas article, quote, shall supersede all local laws or ordinances relating to the regulation of the oil, gas, and solution mining industries, but shall not supersede local government jurisdiction over local roads or the rights of local governments on real property tax. So you read that out, it says, this article shall supersede all local laws or ordinances relating to the regulation of oil, gas, and solution mining. Looks to me superficially like this ordinance says you can't, as a town, say, we're going to zone out hydraulic fracturing. Nevertheless, they did so. The companies took them to court. It went up through the courts. And the New York Court of Appeals, the highest court of New York, said, no, this provision does not prohibit use of the zoning power to zone out oil and gas operations. And they relied on a case they had decided some years earlier on gravel mining. And which allowed a certain amount of exercise of zoning power with relation to gravel mining, despite similar language in that supersession clause. And they relied on New York State Constitution home rule provisions, which gives New York towns home rule power, which is a great deal of power, as the court found. And so by interpreting their past precedent, the language of this law, and the home rule power of the law, they said this may prohibit some forms of local government regulation of particular ways in which oil and gas may be conducted, but it does not supersede traditional zoning powers which say you can zone out industrial uses. So would you have predicted this just reading the language? I would not. Other lawyers clearly did, and they were the ones advising the towns and those opposing hydraulic fracturing. And the Court of Appeals has said, yeah, this language won't supersede these local ordinances. So what's the response? Well, it's possible the New York legislature could go back and write another statute saying, including zoning ordinances, and try again. Or politically, they might have no interest in doing it because it's such a contentious issue, and who knows when regulations will come about. Anyhow, maybe there will be a bunch of takings claims filed against the towns by oil and gas leaseholders, and towns will be forced to pay money or at least litigate for a number of years and give up or throw in the towel. But this is an intersection of an area which we might see as, oh, this is really an environmental issue. How is fracking, is it good for the environment or the economy? Is it a good use of, getting us cleaner natural gas fuel, or is it bad because there might be methane leakage, or is this good for towns, or it's bad for towns because it'll contaminate water? No, it won't. The water contamination is only certain limited, badly constructed wells. Are these environmental law issues, or are they land use law issues? Well, in New York, it turns out it's a land use law issue, and the towns that zoned it out were upheld in doing so. Would a similar result obtain in Colorado with the towns that have zoned out or attempted to zone out the same practice in Colorado? It's a matter of state law. What does the Colorado supersession law say? I don't know. I haven't read it. What does the Colorado Constitution say? What is the Constitution? Pennsylvania has had a case where they've had a long time supersession provision, and the Pennsylvania legislature a year and a half ago strengthened it. We really mean it. You have to allow hydraulic fracturing, unconventional gas development in every zoning district under these state prescribed rules. Last winter, the state Supreme Court, for the first time in its history, used an environmental constitutional amendment passed in 1970 to strike down that strengthened version of the supersession law that the Pennsylvania legislature had passed. Why? They said it destroyed the local government's power to differentiate between environmentally sensitive and not environmentally sensitive parts of the Pennsylvania townships. What about the pre-existing supersession law in the old Pennsylvania Oil and Gas Act? Some of it's still in effect. We're going to have more litigation? Very likely. So it's an example of why land use law in an industrial kind of setting can be just as, or in some cases, more directly relevant to an environmental controversy than what those of you that are environmental lawyers or law students might think of as environmental law practice. So I'm going to wind it up there. I'm going to ask, are there any more questions? I see we have more from the phone, and let me take a couple of those. I think we have 10 minutes or so, and take the first one. I think, can you compare and contrast the merits of Euclidean zoning versus form-based zoning? Can the two be mixed, perhaps using overlays? I actually think they're best used when they're mixed. I think you do want to have some control over uses. That form is not the only thing that you're concerned about, because the number of residents dwelling in a particular area is going to have a large demand for transportation or access to grocery stores or police protection or whatever. So form-based zoning is best used together with some form of Euclidean. In fact, that's the way it's used in most places that have tried form-based codes. How can land use law be used to mitigate or prevent climate change? And are there land use laws that are actively being changed due to impacts of climate change? Wow, we should have a seminar on this. I think this would be a great symposium issue. So whoever submitted this question maybe should follow up with our organizers and see if we can figure out how to do that. It can be used, and a lot of land use law deals with the ways in which we use transportation and in ways in which we use energy. So if we have very energy efficient and compact forms of development, we're going to use less fossil fuels and presumably produce a lot less lower amounts of greenhouse gases. So people that are really interested in climate change focus a lot on transportation. Transportation both influences and is influenced by land use planning and zoning. So definitely related. In terms of adaptation, which was not in the question, this is really important because with sea level rise, we're definitely going to have the issue of what uses are permitted and when can you rebuild or not rebuild, and under what conditions can you rebuild or not rebuild particular use. And there's some really interesting work being done on that, particularly in the post-Sandy expenditures of funds by communities along the eastern seaboard, and actually in the Norfolk area, there's a group called Wetlands Watch that is working very closely with governments in that area, which those local governments have recognized that sea level rise is going to have a very significant effect on their ability to provide services and emergency services and to deal with land use on their waterfronts, and in fact will require relocation, or if you're dealing with capital improvements, where you put those capital improvements. Really important. State of Delaware has a task force that's at work trying to project sea level rise impacts, and that is going to influence, I think, to a significant degree what the state influences its counties to do. And it's one of those kind of, modest growth management states. It has some state influence over county and local development. Not to the extent of Oregon or Vermont, but certainly relevant. I'm going to skip this one. What are the 2 or 3 most important things the next generation of land use lawyers can or need to do, in your opinion? I don't know if I have 2 or 3. I guess I would say I would try to make the world safe for renewable energy. It's a really big land use issue. One of the reasons we did the series of publications on wind power siting, and we actually have a guide for local governments that's downloadable, is because that's going to affect our energy use in a really big way. In addition to where we live and whether we have to commute, where and when you can use solar or wind power or other forms of energy, or energy efficiency retrofit's going to be extremely important. I guess the second thing is, I think it's up to land use lawyers to look out for water and biodiversity issues, and that's another reason we've put up a fair number of publications on that, because the Clean Water Act, we've got all these jurisdictional issues with definition of the waters of the United States, and is the federal government asserting authority over every raindrop or whatever. Well, the federal government may not have the authority, but local governments do. And so to the extent to which work needs to be done, it really needs to be done by the land use lawyers and those advising land use planners and local governments. Question over here.
Yeah, following up on the question about, or your point about renewable energy siting, how does siting, because I know that siting power lines is also up to the states, and so that makes it harder to get, you know, to connect areas with dense populations to areas that actually have space for things like wind farms or solar farms. So is there any movement to try and like, I don't even know if that's possible, but like federalize siting of power lines or things just to update the grid?
So the question deals with siting of power lines, which has a great deal to do with connecting up where people live and work with where power can be generated. And this is, as the questioner notes, primarily an issue that's under the jurisdiction of state law. And is there some thought of federalizing it or updating in some way the way in which we site power lines? And there's a lot of interest, and I'm going to get rapidly beyond my professional expertise because it's a very complex area of law that energy lawyers and the lawyers that deal with regulation of electric power deal with. But the shorter answer is that there was some move to give FERC, the Federal Energy Regulatory Commission, more power over that in the Energy Policy Act, but while still recognizing that the states hold most of that authority. And some of FERC's efforts to exercise that interstate authority were not allowed and were struck down by the court because it essentially didn't give deference to a decision that the state had made. So essentially the court said FERC exercised authority when it was not allowed to do that. This is a fraught political issue. So who should have this control? Should it be state governments? Should it be state PUCs, Public Utility Commission regulators? Should it be FERC? And then is there condemnation power? And where should that condemnation power, the ability to take land from an unwilling landowner, where should that lie? So this issue is fraught, unlikely to be resolved in a short time unless we have massive electric power failures on a national or continental scale. I think there will be no impetus to do anything more than move incrementally in those directions. Utilities are organized, as you may know, regionally in order to manage power flow, and they have a great deal of interest in this issue as well. But we are not like a system where you have a national energy policy that says we're going to build X number of plants and here's where they are and we don't care where the power line should go. This is what's in the national interest. We have a much more chaotic and to some degree locally responsive system than that. I think we have time for one more short question if anybody has one. Yes.
Well, I've heard that there are some smaller towns that they don't want to have big supermarkets in their town, so I guess they use zoning for that.
Yes.
And I'm just interested in like how much power do the local governments have for like deciding what kind of businesses can come to their
Okay, the question relates to the example of towns which have zoned out big box stores or in some cases big box supermarkets over a certain size, and the question is how much power do towns or local governments have, and the answer is it varies by state, and the power that the state has given through their state zoning enabling acts. Most of those state zoning enabling acts would allow those kind of things that would basically deal with the size of units because that's traditional Euclidean zoning. So you have commercial establishments no larger than such and such a size. That's a pretty traditional thing for Euclidean zoning to do. The question might be, how far down could they go? Could they zone, out grocery stores entirely? Maybe. Certainly some states would allow that. So it's been a case of trial and error. I know this has also been an issue in Britain. I don't know if elsewhere there have been these questions about big box and big box groceries, among others, as a way of keeping things walkable and keeping local merchants in business and the like. Another approach is to change the form or zone for the form. You're going back to Arlington County. It's not walking accessible, but there's a 2-story Home Depot with a parking garage in Arlington County because they wouldn't let them build it as the flat parking lot. And they wanted it enough that they were willing to go 2 stories. So the governments have a lot to do with form and size within Euclidean zoning, but not all the time. With that, thank you very much for attending.